Welcome to the Deep Dive. And we just want to start by saying we are so grateful that the source material for this deep dive has been generously made available by the University of London for educational purposes.
Absolutely. It's fantastic material.
And this deep dive is proudly brought to you by Sinorbit Academy, Sri Lanka. Now, to all of you listening, especially those of you, getting ready for exams on this topic, we really wish you the very best of luck.
Yes, good luck. It's a tough area, but hopefully this will help.
That's the aim. This deep dive is specifically designed to help you navigate these, well, pretty challenging waters. Today, we're plunging into an area of law that's, well, it's not just legally intricate, is it? It's also deeply sensitive and, frankly, constantly debated.
Yeah, you're talking about the admissibility of evidence in trials for sexual offenses in the UK.
Exactly. And our focus today is going to be laser sharp on sections 41 to 43 of the Youth Justice and Criminal Evidence Act, 1999. Let's just call it the YJCEA 1999 for short.
Good idea. And those sections 41 to 43, they are absolutely fundamental. If you're grappling with this area of law, you have to understand them.
So that's our mission today.
That's right. Sections 41 to 43 of the YJCEA 1999, they represent Parliament's, most recent major attempt to really control when evidence about a complainant's sexual history can be brought into court.
Right.
So using these detailed excerpts and case analyses provided by the University of London, our mission in this deep dive is to unpack these provisions sort of layer by layer.
Okay.
We need to understand their history, the why behind them, why were they even created, then how the courts have interpreted them, and there are some really pivotal decisions there.
I bet.
And finally, what are the key controversies? What are the ongoing debates? The source materials really give us the map for that.
And look, let's be clear right from the start. This is complex stuff.
Oh, definitely.
It involves a lot of significant case law, and as you mentioned, some of that case law, particularly one major House of Lords decision we'll get into, has been pretty controversial. It's really shaped how the act is applied in practice.
Hugely influential, yes.
So let's set the scene a bit. Why is dealing with evidence, particularly this kind of sexual history evidence, in sexual offense trials, why is it so inherently difficult and controversial?
Well, fundamentally, it really boils down to a conflict, doesn't it? A kind of balancing act between competing human rights, and both are absolutely vital.
Okay, what are they?
So on one side, you've got the defendant's absolute right to a fair trial. That's guaranteed under Article 6 of the European Convention on Human Rights, the ECHR.
The right to defend yourself, essentially.
Exactly. It includes their right to present a full defense, to challenge the evidence against them, and crucially, to bring in evidence that supports their case. They need to be able to test the prosecution's case properly. And in sexual offense trials, that often means testing the complainant's account, particularly around the issue of consent.
Okay, that's one side. What's on the other side of the scale?
On the other side, you have the complainant's rights, primarily their right to respect for their private life, which is protected by Article 8 of the ECHR.
Privacy.
Yes, but it's actually more than just privacy. It's also about dignity. It's about not being subjected to questioning that's irrelevant, intrusive, maybe even humiliating about their past sexual experiences, especially if that questioning doesn't genuinely help uncover the truth about the specific allegation being tried.
The fear being that it shifts the focus unfairly.
Precisely. The big concern is that allowing really wide-ranging questions about sexual history can effectively end up putting the complainant on trial, judging them based on stereotypes rather than focusing on the defendant's alleged actions and the specific question of consent on that particular day.
And I suppose in sexual offense cases, where consent is so often the absolute core issue, finding that fair balance must be uniquely challenging. Often there are only two people who really know what happened.
Exactly. That's often the case. Unlike many other crimes, you might have limited forensic evidence, maybe no independent witnesses. So the case often hinges entirely on the credibility of the complainant versus the defendant.
How does the jury decide?
Well, they have to assess their versions of events, especially regarding whether consent was actually given or, alternatively, whether the defendant had a reasonable belief that there was consent. And this is where past sexual history, if it's allowed in, can potentially have a really huge, maybe disproportionate impact on that assessment.
And it's not like this is all settled law, is it?
Yeah.
Our sources mentioned there's actually an ongoing review by the Law Commission right now.
Yes, that's a really critical piece of context for you to be aware of. Because these difficulties and controversies just haven't gone away, the Law Commission launched a major project back in December 2021. They're doing a wholesale review of how evidence is used in sexual offense prosecutions.
And a major aim is tackling rape myths.
That's right. A specific goal is to find ways to counter these so-called rape myths that can really taint the whole process. They put out a big consultation paper, number 259, in May 2023. It thoroughly reviews the current law, including sections 41, 43, the guidance, how it all works in practice, and it proposes potential reforms.
We should probably clarify what these rape myths are. We hear the term, but what does it actually mean in this context?
Good point. They're essentially deeply ingrained stereotypes, often prejudicial beliefs about sexual assault, about consent, about victims, but they're factually incorrect. They aren't based on evidence or reality.
But they can still influence people.
Hugely. They can significantly and unfairly influence how people, and that could include jurors, maybe even judges sometimes, perceive a complainant's credibility or their behavior.
Can you give an example?
Sure. Like a common myth might suggest that if a victim didn't physically resist very strongly, then it wasn't really rape. Or, crucially for our discussion today, the myth that a person's past sexual conduct with other people tells you something meaningful about whether they consented on a completely different occasion with someone else.
Right.
So the Law Commission's work is trying to make sure the trial process isn't undermined by these kinds of harmful prejudices.
And the source materials note that the final report from the Law Commission is expected sometime in 2024. So this really is a hot topic, as they say, right now in legal journals and academic circles.
It absolutely is. It tells you straight away that despite the legislation we're about to discuss, the 1999 Act, there's still a major debate going on about whether the law is actually achieving what it set out to do.
There's a sense it might not be working perfectly.
Exactly. It suggests there's a fairly broad consensus, or at least a strong feeling, that the system isn't perfect, and that the 1999 Act, even though it aimed to be very restrictive, might not be fully achieving Parliament's original protective goals for complainants.
You mentioned the concept of relevance earlier. It strikes me that this area of law, maybe more than any other, really forces us to think about how relevance isn't always just straightforward common sense, is it?
It absolutely does. It's a brilliant illustration of that. What one person considers relevant based on their own maybe subconscious assumptions or biases about sexual behavior, another person might see it as completely irrelevant and just purely prejudicial.
So it makes you question your own assumptions.
It really compels anyone studying this, and this is important for you as students, to critically examine your own common sense reasoning. You have to challenge potentially harmful assumptions about how people, especially women, behave sexually, and crucially, what inferences can legitimately be drawn from that behavior regarding consent in a specific instance. That critical self-reflection is honestly a key part of mastering this topic.
Okay, so the fundamental legal debate that seems to run through all of this, as our materials lay it out, is this tension. Should the question of whether sexual history evidence is relevant be left mostly to a judge's discretion? Let them decide case by case.
That's one side, yes. The discretionary approach.
Or was Parliament right back in 1999 to say, no, we need to reduce that judicial discretion to an absolute minimum and set down really strict rules in the legislation itself?
That's the core tension, exactly. Judicial discretion versus strict legislative rules. And as we'll see when we look at the case law, especially RVA Note 2, the extent to which the courts, through their interpretation, might have sort of softened or maybe even undermined Parliament's attempt to really constrain their discretion. Well, that's a huge point of debate, academically and practically.
And there's also a related idea mentioned in the materials that maybe the focus shouldn't only be on blocking evidence, but also maybe on educating the jury better.
Yes, that's an important strand of the discussion. It's reflected in guidance, like the Crown Court Compendium, the 2023 version. Section 20-1 in there specifically talks about sexual offenses and warns judges about the dangers of jurors relying on assumptions about behavior, about appearance, things like that.
So a two-pronged approach, maybe.
Possibly. Some commentators argue that alongside having strict rules on admissibility, we also need to equip juries with a better understanding of these myths and biases. Help them make fair decisions. It's probably not an either situation, but potentially a combination of both strategies.
Now, we know sections 41 to 43 of the YJCEA 1999 apply to all sexual offenses, but for this deep dive, we'll follow the source materials and focus primarily on allegations of rape. Just as a quick reminder for everyone listening, especially for exams under Section 1 of the Sexual Offenses Act 2003, the offense of rape has three essential elements. The prosecution has to prove all three beyond reasonable doubt. What are they again?
Right. The three key elements for rape under Section 1 are: first, intentional penetration of the complainant's vagina, anus, or mouth with the defendant's penis. Second, that this penetration was without the complainant's consent. And third, that the defendant did not reasonably believe that the complainant consented.
And it's usually that second or third element, consent or belief in consent, where the admissibility of the complainant's sexual history becomes a flashpoint, right?
Exactly. The defense often wants to introduce it because they claim it's relevant to arguing either that there was actual consent, element 2, or that the defendant reasonably believed there was consent, element 3.
Okay, so to really understand why the 1999 Act was seen as necessary, we need to step back in time a bit. Where did these legislative efforts to restrict this kind of evidence actually begin?
Well, the first really significant legislative step was the Sexual Offences Amendment Act, 1976. This was Parliament's initial attempt to put statutory restrictions on admitting evidence about a complainant's extraneous sexual history.
Extraneous, what does that mean here?
That's a key term. Extraneous means sexual history with people other than the accused. So, not about any past relationship with the person on trial, but with third parties.
And the push for that 1976 Act came from a report, didn't it? The Heilbronn Report.
Precisely. The report of the Heilbronn Advisory Group on the Law of Rape in 1975 was incredibly influential. They were really concerned that without any specific legal controls, defense lawyers could and sometimes did ask incredibly wide-ranging, often irrelevant, and deeply intrusive questions about a complainant's sexual past with other men.
Why was that seen as a problem?
Because it often felt less like trying to find the truth about the specific allegation and more like just attacking the complainant's character or lifestyle, the putting the woman on trial problem we mentioned. The Heilbronn group generally accepted that a previous sexual relationship between the complainant and the accused might potentially be relevant. But they generally thought history with other men was irrelevant to whether she consented to sex with the defendant on the specific occasion charged.
Okay, so the 1976 Act was the response. Section 2 was the key part. What did it actually do?
Right. Section 2 of the 1976 Act essentially said you needed the court's permission, the leave of the court, before you could bring in any evidence or ask any questions in cross-examination about any sexual experience of a complainant with a person other than the defendant.
So any history with third parties needed the judge's okay first.
Exactly. If the defense wanted to bring up anything about the complainant's past with anyone other than the man in the dock, they had to apply for leave.
And what was the test for getting that leave under the 1976 Act?
The test was that leave should be granted only if the judge was satisfied that it would be unfair to that defendant to refuse to allow the evidence to be adduced or the question to be asked.
Unfair to the defendant. That sounds reasonable on the face of it, like it protects their right to a defense.
It sounds reasonable, yes. But in practice, it turned out to be something of a loophole. And the way the courts interpreted that phrase, unfair to the defendant, significantly weakened what Parliament seemed to intend.
And this brings us to a really important case that showed this weakness. Viola. That's Viola, 1982.
Yes, Viola is crucial because the Lord Chief Justice at the time, Lord Lane, gave an interpretation of the 1976 Act that many people felt just, drove a coach and horses through Parliament's intentions.
What did he say?
He basically said that judges should generally stop questions that were just about the complainant's general credit or character. So you couldn't just use sexual history to paint her as, promiscuous or unchaste and therefore untrustworthy. But, and this is the crucial part, he said questions that were relevant to an issue in the trial in the light of the way the case is being run, issues like consent or belief in consent, those questions should normally be permitted.
Wait, so even if the sexual history was with someone other than the accused, if the judge thought it was somehow relevant to consent or belief in consent in this specific trial, Lord Lane was saying they should probably allow it under the unfairness test.
That's exactly the effect of his reasoning. He essentially prioritized the traditional common law rule of relevance, as the judge saw it, over Parliament's attempt to create a special, more restrictive rule just for this type of evidence. The unfair to the defendant test got interpreted very broadly. It gave judges a lot of discretion to let evidence in if they could see any link, even a tenuous one, to the core issues of consent or belief in consent.
So that broad interpretation meant the 1976 Act wasn't actually restricting very much in practice.
That was certainly the conclusion reached later on. There was a Home Office report in 1998 called Speaking Up for Justice. It looked into how the 1976 Act was working, and it found that leave was actually being granted in the vast majority of applications made under Section 2.
So it wasn't working as intended.
No. The report basically concluded that the Act was not effectively restricting sexual history evidence and was failing to give complainants the protection Parliament had wanted. The perception was really strong. The judiciary just wasn't applying the 1976 law in the strict protective way Parliament had meant.
And that failure, that feeling that the courts had undermined the 1976 Act, is the direct reason we then got the Youth Justice and Criminal Evidence Act 1999.
Absolutely. The 1999 Act, particularly Sections 41 and 43, was drafted specifically to fix the perceived problems of the 1976 Act and the Viola interpretation. Parliament's clear aim this time was to severely curtail judicial discretion. They wanted a much stricter, more rule-based system. They tried to prescribe very limited and very specific circumstances, sometimes called gateways, through which evidence of previous sexual history could possibly be admitted. They were trying to take the decision-making power away from the judge's broad discretion and put it firmly into the statute itself.
Okay, so the 1999 Act is meant to be much, much stricter and leave judges with far less wiggle room than the 1976 Act, especially after Viola. Let's really nail down the main differences between these two acts, because you're saying understanding this shift is critical.
It really is. This is a key point for you to grasp, so let's be clear. There are two absolutely major differences you must remember. First, the first principal difference. The 1976 Act's restrictions, remember, they only applied to history with people other than the accused, had no application at all to previous sexual experience between the complainant and the accused.
So under the 76 Act, if the defense wanted to bring up a past relationship between the defendant and complainant, they didn't even need the judge's permission. The Act just didn't cover it.
That's correct. The Heilbronn Group and the 1976 Act basically treated that as potentially relevant and outside the scope of the restrictions, but the 1999 Act changed that completely. Section 41 does potentially restrict evidence even of a previous sexual relationship between the complainant and the accused.
Wow. Okay, so now, even for history with the accused, the defense needs to satisfy the conditions in the 1999 Act and get leave from the judge.
Yes. That's a massive change. That's difference number one.
Okay, what's the second big difference?
The second major difference is the test for granting leave when leave is required. Under the 1976 Act, as interpreted in Viola, leave could be given if the judge thought it was unfair to the defendant to refuse it. And we saw that was interpreted quite broadly, letting in evidence seen as relevant to core issues.
A test that gave judges a lot of discretion.
Right. Now, under the 1999 Act, specifically Section 41, Parliament set a much, much higher bar. Leave may only be given if the court is satisfied of two things. One, the evidence or question is relevant to an issue in the case, and two, that refusing leave might render the jury's conclusion unsafe.
Unsafe. Now, that word sounds familiar. Where have we heard that before in criminal law?
You've definitely heard it because unsafe is the single ground on which a conviction can be overturned on appeal under the Criminal Appeal Act in 1968.
Ah, okay. So Parliament deliberately linked the test for letting this evidence in to the test for quashing a conviction.
Exactly. By using the word unsafe, Parliament was sending a very strong message to judges. They were essentially saying, you can only let the sexual history evidence in if excluding it creates a real risk that the jury will convict someone wrongly, so wrongly, that the conviction would likely be overturned as unsafe on appeal. This was Parliament's deliberate attempt to really tie judges' hands and dramatically reduce their discretion compared to that looser unfairness test from 1976.
That really does underline Parliament's intention to create a very, very restrictive system in 1999.
It absolutely does. The wording of the statute, that change in the test for leave from unfair to unsafe, it clearly shows Parliament wanted to shift power away from broad judicial discretion and towards much tighter statutory rules.
Okay, so with that crucial background in mind, let's turn our full attention now to the heart of the current law. Sections 41 to 43 of the Youth Justice and Criminal Evidence Act 1999. As the source materials rightly warn us, these sections are dense. They require really careful reading and analysis.
They absolutely do, and they contain some critical distinctions that are easy to miss, but are absolutely vital if you want to apply the law correctly. For instance, one key distinction the Act makes right away is between trials where the issue is one of consent and trials where the issue is not one of consent. That distinction is central to how Section 41 actually works.
And thinking about a rape trial, the defense might raise different arguments, can't they? They could say the complainant actually consented. Or they might argue that even if she didn't technically consent, the defendant reasonably believes she did. or maybe both.
That's right. They can run either or both defenses. And this is really important when you're looking at a problem scenario. You absolutely have to look closely at what the defendant is actually recorded as saying, maybe in their police interview or through their lawyers, to figure out precisely which defense or defenses they are actually putting forward. Is it actual consent? Is it reasonable belief in consent? Knowing that tells you which parts of Section 41 might potentially be engaged.
And here's a point the statute makes very clear, but it can trip you up if you're reading it fast. Section 42(1) of the Act. It says that specifically for the purposes of Section 41, an issue about the defendant's belief as to consent is not treated as an issue of the complainant's consent itself.
Yes. This is a crucial and maybe slightly counterintuitive statutory definition that you absolutely must remember. Let me repeat it because it's so important. Section 42(1) explicitly states that the issue of the defendant's belief in consent is legally separate from and not considered part of the issue of the complainant's actual consent when you're applying Section 41. This distinction has a big impact on which specific gateways within S.41 might open up.
Okay, keeping that distinction, consent versus belief in consent, firmly in mind, let's tackle the basic questions about Section 41 that the source material encourages us to ask. First off, what does Section 41 generally prohibit? What's the starting point?
Okay, the starting point is Section 41, subsection 1. It lays down the general rule: no evidence can be adduced and no question can be asked in cross-examination about any sexual behavior of a complainant unless the court gives leave. So the default position is exclusion.
And sexual behavior, that term itself is interpreted quite widely by the courts, isn't it?
Yes, it is. Cases like Benrijab 2012 and RVT 2021 show that it's not just limited to, say, penetrative sex acts. It can cover a whole range of conduct, maybe even things like appearance or communications if they're seen as relevant to a person's sexuality or their interactions in a sexual context. The breadth of the term sexual behavior just reinforces how wide the general prohibition is intended to be.
So generally prohibited. What are the overall conditions then under Section 41 for when leave can be given to let this kind of evidence in?
Right. This takes us back to that strict test in the 1999 Act we just discussed. Leave may only be granted if the court is satisfied of two things. First, the evidence or question must be relevant to an issue in the case. And second, excluding that evidence or question might render the jury's conclusion unsafe. Both parts of that test have to be met: relevance and the risk of an unsafe conclusion.
Okay, now let's circle back to that tricky point about belief and consent from Section 42(1). Section 41(3) then goes on to list some specific gateways exceptions where leave might be granted. Section 41(3)(c) seems particularly relevant here, doesn't it? It mentions consent and belief in consent.
Yes. Section 41(3)(c) is a key gateway. It says leave can potentially be given if the evidence relates to sexual behavior, and the purpose is to rebut prosecution evidence, or if it is relevant to an issue of consent, or, crucially, to an issue of whether the defendant believed the complainant consented.
But hang on, didn't Section 42(1) just tell us that belief in consent is not an issue of consent itself? How does that fit with S.413(c) mentioning both?
You've hit on exactly where the statutory drafting gets complex and has caused headaches. Since S.421 separates belief from consent, it raises this question. If evidence is relevant only to the defendant's reasonable belief in consent, and not relevant to whether she actually consented, can that evidence potentially get in under the belief part of S.413? Or does the strict separation in S.421 somehow limit what kind of evidence can even be considered relevant to belief in the first place?
So it's about how these two sections interact.
Precisely. This question about the interplay between S.421's definition and S.413c's gateway, especially that belief limb, has been a major point of judicial interpretation and, frankly, controversy. It really highlights the incredibly detailed level of statutory analysis you need for this topic.
It sounds like Parliament laid down these very specific, maybe even slightly contradictory rules, and then the courts were left to figure out how they actually worked in real trials, especially when a defendant is arguing my right to a fair trial is at stake.
That's a very good way of putting it. And that exact struggle between Parliament's apparently very strict rules and the defendant's fundamental Article 6 ECHR right to a fair trial came to a dramatic head in a truly landmark case.
Which brings us inevitably to the absolutely central, incredibly influential, and yes, highly controversial House of Lords decision. RVA, Note 2. That's R versus A, number 2, 2001 UKHL 25. If you are studying this area, this is the case you absolutely need to understand inside out.
RVA Note 2 is completely pivotal. It's the case where the highest court in the UK at the time interpreted sections 41 to 43, and in doing so, fundamentally reshaped how they're applied, particularly when it comes to evidence about a complainant's sexual history with the accused.
And the key tool they used to do this was Section 3 of the Human Rights Act, 1998.
Exactly. Section 3 of the Human Rights Act was the mechanism.
And just to remind everyone, Section 3 of the Human Rights Act basically requires UK courts to read and apply legislation whenever possible in a way that's compatible with the rights set out in the European Convention on Human Rights, rights like Article 6, the right to a fair trial.
That's precisely it. The law lords in RVA, Note 2, felt that applying Section 41 absolutely strictly, exactly as Parliament seemed to have written it, with its very narrow gateways and high unsafe test, could, in certain specific situations, actually prevent a defendant from putting forward evidence that was genuinely necessary for their defense. And doing that, they thought, would violate the defendant's Article 6 right to a fair trial.
So they used Section 3 to reinterpret the Act.
Yes. They used Section 3 HRA to interpret Section 41 in a way they believed was compatible with Article 6, even if that meant reading the statute in a way that seemed to depart quite significantly from what Parliament's very restrictive wording appeared to intend.
Okay, this is clearly a crucial case. Let's walk through the key aspects of it and the court's reasoning in detail. We can use the questions from the source material to guide us. First off, what were the basic facts of the case in RVA? Nuckin 2. What was the charge? What was the defense?
Okay, the defendant was charged with rape. His defense wasn't just denying the specific events on the day in question. He claimed that the complainant had, in fact, consented. And a key part of his defense rested on the existence of an alleged previous sexual relationship between him and the complainant. He wanted to tell the jury about that history.
And what specific evidence did he want permission to introduce at his pretrial hearing?
He specifically sought leave permission from the judge to bring in evidence about and to cross-examine the complainant on that alleged prior sexual relationship between the two of them.
Now, why did he even need leave to do that under the YJCEA 1999? This goes back to that first big difference you highlighted between the 1999 Act and the 1976 Act.
Exactly. This case perfectly illustrates that first key difference. Remember, under the 1976 Act, evidence about previous sexual history with the accused simply wasn't covered by the restrictions. No leave needed. But under the 1999 Act, evidence of any sexual behavior, and that includes a previous sexual relationship between the complainant and the accused, falls under that general ban in Section 41(1), which means leave is now required.
Got it. Now, the trial judge in RVA had actually refused leave, right, and excluded the evidence. But the Court of Appeal disagreed. Why did they say the trial judge got it wrong?
The Court of Appeal, with Lord Justice Rose giving the judgment, essentially felt that Parliament couldn't possibly have intended to shut out evidence of a previous sexual relationship between the actual complainant and the actual accused, especially when that evidence seemed genuinely relevant to the core issue of consent on the specific occasion being charged.
They thought it was too important for a fair trial.
Pretty much. They reasoned that such evidence, if it was genuinely relevant, was so fundamental to ensuring a fair trial under Article 6 that it simply had to be potentially admissible. So they concluded that the Act, if interpreted correctly, perhaps with Article 6 in mind, didn't actually prevent that kind of evidence from being considered for admission under Section 41.
And that class trial judge saying no, Court of Appeal saying yes, maybe led to the specific question that went up to the House of Lords.
Yes, the Court of Appeals certified a specific question of law for the House of Lords to answer. It essentially asked them to clarify the exact effect of Sections 41 to 43 of the YJCEA 1999 on the admissibility of evidence about a prior sexual relationship between the complainant and the accused, specifically when the relevance of that evidence was said to be to the issue of consent on the occasion charged.
Okay, let's dig into the House of Lords judgments now. Lord Slynn gave one of the leading opinions. What did he say had become clear in recent years about how sexual history evidence was sometimes being misused?
Lord Slynn noted that it had become pretty obvious that evidence about a complainant's sexual history was often being brought in, not because it had any real relevance to the facts of the specific case, but simply to try and prejudice the jury against the complainant. Or to suggest, unfairly, that just because she'd had sex before, she was somehow more likely to have consented this time, or less likely to be telling the truth.
And why did he think it was necessary for the law to strongly prohibit questioning about sex with men other than the accused?
Well, he basically reiterated the concerns that had driven both the 1976 and the 1999 acts. He said that kind of questioning rarely had any real probative value, any real usefulness in finding the truth about the specific allegation. Instead, it often served mainly to put the woman on trial, relying on those harmful stereotypes and prejudices rather than objective facts relevant to consent in this instance.
But Lord Slynn also acknowledged that even evidence of previous sex between the complainant and the accused could be dangerous, didn't he?
Yes, he did. He recognized that while history with the accused might seem potentially more relevant than history with others, even that kind of evidence could be misused. It could be used unfairly to suggest a sort of general propensity to consent to sex with this particular accused, rather than providing genuine insight into whether consent was actually given on the specific occasion charged.
So the risk is using it to argue, well, she consented with him before, so she probably consented this time too.
Exactly. That's a classic example of flawed propensity reasoning, judging present actions based on past behavior, which the act was trying hard to prevent.
What was the obvious conflict that Lord Slynn identified, the one that was really driving the court's whole approach in this case?
The obvious conflict he highlighted was the one we started our discussion with. That fundamental tension between the defendant's absolute right to a fair trial under Article 6 ECHR and the complainant's right to respect for her private life and dignity under Article 8 ECHR. He saw the law in this area as having to navigate that very difficult tightrope. And he also made the important point that unfair or intrusive cross-examination in these cases isn't just damaging for the individual complainant involved. It can also have a wider chilling effect on the administration of justice generally, potentially discouraging other victims of sexual offenses from coming forward and reporting crimes in the future.
Which brings us back squarely to the Human Rights Act, 1998. Remind us again, what does Section 3 of the HRA require UK courts to do when interpreting legislation?
Section 3 of the HRA imposes a very strong duty on courts. It says they must read and give effect to legislation, both primary acts of Parliament and secondary legislation, in a way that is compatible with the Convention rights, so far as it is possible to do so. It's a powerful interpretative tool.
And how did Lord Slynn suggest Section 3 HRA could be used to interpret a specific phrase in the Act, the phrase at or about the same time, in Section 41.3?
Right, Section 41.3b is another one of those gateways. It allows evidence of sexual behavior if it's alleged to have happened at or about the same time as the event charged. Lord Slynn suggested that Section 3 HRA could potentially be used to interpret that phrase at or about the same time quite flexibly. His underlying point was that if some evidence was truly relevant and necessary for a fair trial under Article 6, the court might need to read at or about the same time somewhat broadly to make sure crucial evidence wasn't unfairly excluded just because it happened slightly outside a very strict, narrow time window.
Okay, now let's turn to Lord Steen's judgment. His is often seen as the most significant one in RVA, Note 2, the one that's had the most impact. How did he say Section 41, and particularly that gateway in Section 41.3c, should be read?
Lord Steen was incredibly clear, very direct. He stated quite forcefully that Section 41, and especially Section 41.3c, the gateway allowing evidence relevant to consent or belief in consent, must be read and given effect in a way that is compatible with Article 6 of the ECHR, the right to a fair trial. And the way to do that, he said, was by using Section 3 of the Human Rights Act.
So he basically laid it down. Interpret this section through the lens of the Human Rights Act.
Absolutely. That was the critical step, the key interpretive move. He explicitly said that Section 41.3c had to be read as allowing the admission of evidence about previous sexual history, particularly history with the accused, if applying ordinary common law principles of relevance, that evidence was necessary to make the trial process fair under Article 6.
So Lord Steen was effectively saying, look, Parliament tried to make this law really, really strict, maybe too strict. But the Human Rights Act forces us, the courts, to interpret it more flexibly to guarantee a fair trial for the defendant.
That's precisely the implication of his reasoning, yes. He used the Human Rights Act as a kind of interpretive lever to ensure that relevant evidence, especially concerning prior sexual history with the accused, could potentially get through the gateway in S.413, even though Parliament's own drafting, with its focus on the unsafe test, seemed designed to make that incredibly difficult.
What was the overall practical effect of their decision then, according to Lord Slynn and Lord Stein? What did it mean for the admissibility of this kind of evidence?
They concluded that the practical effect of their interpretation was this. evidence of a previous sexual relationship between the complainant and the accused, where that evidence was genuinely relevant to the issues of consent or belief in consent on the specific occasion charged, could now be admitted under Section 41(3)(c). Provided, of course, it still met the overall test, it had to be relevant, and its refusal would have to risk rendering a conviction unsafe. And Lord Stein was very clear. Applying this interpretation, the trial judge in the specific case before them had been wrong to exclude the evidence of the prior relationship that the defendant wanted to introduce.
So the headline is, evidence of a previous sexual relationship with the accused became, in principle, potentially admissible under their reading of S.413c, thanks to Article 6 in the Human Rights Act.
Yes, but, and this is a really crucial point Lord Stein made, he was very careful about how that prior sexual relationship with the accused could be relevant. He stressed it was not about general propensity. It's not relevant just because it suggests the complainant is the type to consent.
Okay, so it's not relevant just to say, well, they had sex before, so she was probably up for it this time too.
No. That's exactly the kind of flawed, prejudicial propensity reasoning that Section 41 was designed to exclude, and Lord Stein was adamant about that.
So how can it be relevant then, according to Lord Stein? What's the legitimate basis?
Lord Stein explained that evidence of a previous consensual sexual relationship between this specific complainant and this specific accused could be relevant not as evidence of general character or propensity, but because it might provide absolutely essential context to understand their relationship or their interaction leading up to the alleged offense.
Context. What kind of context?
It could shed light on the specific dynamic between those two people. Their understanding of each other's boundaries, maybe their communication styles, perhaps their established sexual preferences within that particular relationship. And that specific context could, in certain factual situations, be genuinely relevant to understanding whether consent was actually given or reasonably believed to have been given on the specific occasion charged. The relevance comes from the specific history of that relationship, not from making broad generalizations about behavior.
It's quite a subtle distinction. Can you give us those concrete examples from the judgment? What kind of previous encounter between the accused and complainant would not be relevant according to the law lords, and what kind might be?
Okay, a clear example of what they would not see as relevant is if the defense just wants to bring up any old prior sexual encounter between the two, simply to argue, look, she consented before, so she's more likely to have consented this time, or maybe she has a history of sex with him, so her claim of non-consent now is less believable. That's pure propensity or character reasoning, and that's exactly what S.41 is meant to stop.
Right, that's the prohibited stuff. What about an example of what might be relevant and potentially admissible?
Well, an example that might be deemed relevant, and this mirrors the situation in RVA Nerdo 2 itself, is where the defense argues that the previous encounters establish a clear pattern of consensual sexual activity within the context of an ongoing relationship between these two specific individuals. And crucially, that pattern or context is argued to be directly relevant to understanding the specific interaction and the alleged lack of consent on the occasion charged. For instance, if the defense case is that the sexual activity on the day was just part of a long-standing established consensual pattern of behavior between them, then evidence of that previous history might be needed to provide the crucial context to understand that specific interaction. In those circumstances, it might be admissible.
So it always has to link back to providing specific context for that relationship and that alleged incident, not just making general points about past behavior. That sounds like a very fine line for courts to draw in practice.
It is an incredibly fine line, and it requires a very careful analysis of the specific facts of each case and the precise way the defense is arguing that the evidence is relevant.
What did Lord Stein say about how the YJCEA 1999 deals with the other type of evidence, prior sexual relationships between the complainant and persons other than the accused?
Lord Stein clearly viewed the act as being significantly more restrictive when it comes to evidence of a complainant's sexual history with other people, with third parties. He acknowledged it wasn't an absolute ban, theoretically. Such evidence could potentially come in under very limited circumstances, maybe if it was genuinely relevant to an issue like motive to fabricate the allegation, which might fall under Gateway 10413A. But generally, he saw the gateways for admitting this type of third-party evidence as being much, much narrower than for history with the accused.
Why the difference?
Because the risk of unfair prejudice and the risk of relying on those harmful myths and stereotypes is generally considered much, much higher when the sexual history involves someone completely different from the defendant.
And Lord Hope, another law lord in RVA Yelhuntu, he provided some helpful examples of issues that might fall within that other gateway, Section 41(3)(a), didn't he? That's the one for evidence relevant to issues other than consent or belief in consent.
Yes, Lord Hope did. He gave some useful examples of scenarios where sexual history evidence might be relevant to an issue other than consent belief and therefore potentially admissible under S.413a, provided, of course, it still meets the overall S.41 test. Relevant to that other issue, A&D refusal would risk an unsafe conviction. His examples are important because they remind us that S.41 isn't only about consent. They included things like
Okay, what were they?
1. Establishing a possible motive for the complainant to fabricate the allegation. For instance, maybe to conceal a consensual encounter with someone else. 2. Challenging the identity of the perpetrator if the defense is saying, it wasn't me, it was someone else she was with. 3. Maybe showing that a physical injury the complainant suffered was actually caused by prior consensual sexual activity, not by the alleged assault. Or 4. Perhaps refuting a defendant's alibi by showing prior contact between him and the complainant that he denies.
So in those examples, the sexual history isn't being used to suggest she consented, but to challenge the prosecution's case on a completely different specific point.
Exactly. It's about relevance to a different factual issue in the trial.
Okay, so summing up RVA, No. 2. It's the massive, heavyweight decision where the House of Lords used the Human Rights Act to essentially read down Section 41, ensuring it allowed evidence of prior sexual history with the accused if that evidence was genuinely relevant and necessary for a fair trial, interpreting Parliament's super strict language more flexibly than intended.
That's a very good summary. It is the case. And its interpretation, especially Lord Staines' reasoning, is the fundamental reason why Section 41, despite Parliament's apparent intentions, does not operate as an absolute ban on admitting evidence of prior sexual history with the accused.
And how was this decision received at the time? The source material mentions there were pretty strong reactions.
Oh, yes. RVA No. 2 was instantly controversial, and it has honestly remained so ever since. It drew significant praise from some people, but also attracted really strong criticism from others.
Let's hear the arguments in favor first. Why did some people praise the decision?
Well, those who praised RVA No. 2 generally argue that it was a necessary and constitutionally correct application of the Human Rights Act. They contend that completely excluding genuinely relevant evidence of a prior sexual relationship between the accused and the complainant could be absolutely devastating for the defense. It could make it impossible for them to run certain legitimate arguments about consent or belief in consent, and therefore it would violate the defendant's fundamental right to a fair trial under Article 6. They see the court's decision as upholding a vital principle that legislation has to be interpreted compatibly with convention rights where possible, and, crucially, preventing potential miscarriages of justice.
Okay, that's the fairness for the defendant argument. What about the criticisms? Why did others dislike the decision?
Critics argue that the House of Lords basically overstepped its constitutional role and effectively rewrote Section 41. They feel it undermined Parliament's clear intention, based on the failures of the 1976 Act, to create a very strict, highly protective regime for complainants. They argue that the use of Section 3 of the Human Rights Act was perhaps too bold or aggressive, going beyond mere interpretation, and they worry that the decision, despite Lord Staines' careful distinctions about context versus propensity, risks reintroducing the very dangers the 1999 Act sought to avoid, putting the woman on trial again, or allowing evidence based on harmful myths, even if subtly. They question whether the court's interpretation truly aligns with the protective spirit and aims of the 1999 Act.
So it's seen by some as a crucial safeguard for defendant rights, but by others as weakening protections for complainants and basically overriding Parliament's democratic will. That's a classic legal tension right there.
It absolutely is. And that very tension has continued to play out in all the cases that have come after RVA No. 2, as lower courts have had to grapple with applying its principles to all sorts of different factual scenarios.
Speaking of those subsequent cases, the way Sections 41 to 43 have been applied since RVA No. 2 has generated a pretty hefty body of further case law, hasn't it?
It certainly has. And as the source material rightly points out, trying to apply the principles from A No. 2 to the messy facts of specific cases can be really challenging. And honestly, the logic in some of these later decisions can sometimes be quite difficult to follow. Mukadi is mentioned specifically as a case where the reasoning has been very heavily debated and criticized.
When you're analyzing these later cases, and this is important for students tackling problem questions, the source suggests it's really helpful to pinpoint which specific subsection of Section 41 the court was actually considering. and then understand whether leave was granted or refused, and crucially, why they made that decision.
That analytical approach is absolutely essential. It helps you see how those general principles from A No 2 actually translate into practice on the ground. Let's look at a few key examples from the cases listed in the source material. They really illustrate the law in action post A No 2.
Okay, let's start with Martin 2004. Which subsections of S.41 were in play there, and what did the Court of Appeal decide about whether leave should have been granted?
Right. In Martin, the Court of Appeal looked at both S.41 Prifier, that's relevance to issues other than consent or belief, and also S.413C, relevance to consent or belief. They actually concluded that the trial judge should have granted leave, at least for some of the evidence. Interestingly, the court held that evidence relating to the complainant's previous sexual behavior with someone other than the accused could potentially be relevant under S.413, specifically to the defense of reasonable belief and consent, even if it wasn't relevant to whether she actually consented.
Really, even with a third party?
Yes, for the belief aspect, potentially. They also suggested some of the evidence might have been relevant under S.413A to an issue like motive for fabrication, which fits with Lord Hope's examples in A No 2. So Martin shows the courts exploring the possibility, albeit maybe a narrow one, of relevance to the belief limb of S.413C, and also reinforcing that S.413A gateway for issues like motive.
So Martin suggests that even evidence about history with a third party might sneak in, not for actual consent, but maybe for belief in consent or perhaps motive.
Yes, but always remember that high threshold still applies. It has to be genuinely relevant to that specific issue, and refusal would have to risk an unsafe conviction. Martin shows the courts weren't completely slamming the door on third-party history after A No 2, but the circumstances where it would get in seemed very narrow indeed.
Okay. What about Mukadi, 2003? This case is specifically highlighted in the materials as illustrating the subjective nature of relevance.
Mukadi. Yes. This one primarily concerned Section 41(3)(b), which is the gateway for sexual behavior occurring at or about the same time as the alleged offense. Mukadi is such a stark example of how subjective the assessment of relevance can be, mainly because the trial judge and the Court of Appeal reached completely different conclusions based on the exact same piece of evidence.
What was the evidence?
It concerned the complainant's interaction with a male stranger getting into his car, exchanging phone numbers shortly before she met the defendant. The trial judge refused leave, basically saying that interaction with stranger A was irrelevant to what happened later with the defendant, stranger B. However, the Court of Appeal, in a decision that sparked a lot of criticism, found it was relevant under S.413B as happening at or about the same time, and they thought it could potentially shed light on her intentions or state of mind when she met the defendant.
So different judges saw relevance completely differently.
Exactly. The fact that experienced legal minds could disagree so fundamentally about whether that evidence was relevant just highlights how difficult and potentially subjective this area is. And as the source notes, there are still very strong differing views today about which court actually got it right in Mukadi.
We definitely need to come back and dissect the specific reasoning chain in Mukadi soon, because it sounds like a perfect example of the problems here. But let's quickly look at a couple more cases first. What about White 2004? What did the Court of Appeal say in that case about applying Section 3 of the Human Rights Act to Section 41(3)(c when the evidence involves sexual acts with men other than the accused?
Right. In White, the defense again wanted to bring in evidence about the complainant's sexual behavior with men other than the defendant. They argued it was relevant to consent or belief in consent under S.41c. The Court of Appeal confirmed the principle from RVA, No. 2. Yes, Section 3 of the Human Rights Act could potentially be used to interpret S.41c to allow evidence of sexual history with others, but only if it was genuinely relevant to consent or belief in consent in that specific case, and it met the high unsafe test.
But did they think it was relevant in White?
No. They specifically cautioned that the circumstances where third-party history would actually be genuinely relevant under S.413c would be extremely rare. And on the specific facts of White, the Court of Appeal agreed with the trial judge's decision not to grant leave. They found the proposed evidence was not sufficiently relevant to the issues. In fact, they felt it seemed to rely on exactly the kind of generalized propensity reasoning. You know, she did X with person Y, so she likely consented to Z with the defendant that Section 41 was designed to exclude. So White shows that even though A No 2 provided the interpretive tool, HRA SB3, actually getting third-party history admitted under S.413c remained very, very difficult in practice.
So the takeaway is, Even after RVA No. 2, getting evidence of history with third parties admitted is still an extremely high hurdle to clear.
Absolutely. The courts have generally maintained a much stricter approach to third-party history compared to history with the accused. The potential for prejudice is just seen as much higher.
Okay. How about R 2003, R versus R? Which subsection was key there?
RVR 2003 is another important example, focusing on Section 41.3, relevance to issues other than consent. In that case, the Court of Appeal again found that the trial judge should have granted leave. Why? Because they decided the evidence was relevant to a potential motive for the complainant to fabricate the allegation. And motive to fabricate is a relevant issue in the trial, separate from the issue of consent itself.
So it reinforces that S.41 gateway.
Exactly. It shows that S.413 remains a viable route for admitting evidence, just as Lord Hope outlined in A No. 2, provided the relevance is genuinely to an issue other than consent, like motive, and it meets that crucial unsafe threshold.
And Hamadi 2007, what did that case clarify about how RVA No. 2 affects the interpretation of Section 41, 3, and 5?
Hamadi is significant because it specifically revisited how Section 41 applies to previous sexual activity between the complainant and the accused, particularly after A No. 2. In Hamadi, the appellant argued that their previous sexual relationship made it more likely the complainant had consented on the occasion charged. The Court of Appeal flatly rejected this argument. They upheld the trial judge's refusal of leave.
Why? Didn't A No. 2 open the door for that?
Not automatically. The court in Hamadi emphasized that RVA No. 2 did not mean that any evidence of prior sex with the accused was now automatically admissible. It still had to be genuinely relevant to the specific issue of consent or belief in consent on the particular occasion charged. It couldn't just be evidence used vaguely to suggest a general propensity to consent or to argue that because she did it before with him, she must have done it again this time. Hamadi clarified that Section 41.5, which explicitly states that evidence is not relevant under S.413c if its only purpose is to show a general propensity to consent with the defendant, was not somehow overridden or canceled out by RVA No. 2. A No. 2 allows evidence if it's relevant contextually to the specific issue, remember, not just to show general propensity.
That's a really important clarification. And finally, what about Beadle 2007?
Beadle. In that case, the defense basically wanted to introduce evidence of the complainant's sexual history to suggest she was a person of, well, promiscuous as character, and therefore, they argued, more likely to have consented. The Court of Appeal firmly rejected this. They completely agreed with the trial judge's refusal to grant leave. Because Beadle is a crystal clear example of the courts rightly excluding evidence that is being offered purely to attack the complainant's character or lifestyle, it relies on outdated, harmful stereotypes. It reinforces the fact that the strict rules in Section 41 are specifically intended to prevent exactly this kind of prejudicial questioning. Arguments based purely on character or promiscuity simply do not meet the relevance test, let alone the unsafe test. And the source also mentions other cases, RVT 2004, Guthrie 2016, Evans 2016, Harris 2009. We don't need to go into the facts of every single one, but you should know that these cases provide further valuable illustrations. They help refine the boundaries of how courts have applied these principles, particularly under that tricky gateway S.413c. They show the ongoing challenges judges face in deciding when a specific piece of sexual history evidence is genuinely relevant to consent or belief in consent on the occasion charged, versus when it's just irrelevant or unfairly prejudicial. Studying these helps you see the practical application of the law.
Okay, this intricate web of case law, especially everything that's happened since RVA No. 2, brings us right back to that fundamental concept we keep touching on, relevance. And the Mukadi case is often held up as a particularly worrying example of how the assessment of relevance can potentially go wrong, maybe relying on unstated problematic assumptions.
It really is. Now, in evidence law generally, when a court rules that a piece of evidence is relevant, they are making a specific legal judgment. They are saying that the evidence, if the jury believes it, logically tends to make a fact that's an issue in the case, like whether the intercourse was consensual, either more likely or less likely.
But crucially, they're not saying that the evidence definitely does, in reality, make the defendant's version of events more probable.
Exactly. That's a critical distinction you have to grasp. The court isn't deciding the ultimate truth of the inference the defense wants the jury to draw. They're deciding whether a jury could legitimately draw that inference from the evidence presented. And this is where the difficulty and the controversy really bite. Because what counts as a legitimate inference can, sometimes consciously, but maybe often unconsciously, be shaped by underlying assumptions or generalizations about human behavior, especially sexual behavior. And that is precisely the criticism that's been leveled so strongly at the reported reasoning in the Mukadi case.
Okay, let's really break down that chain of reasoning from the Mukadi judgment, reportedly from paragraph 11, because the source says it's a powerful illustration of the potential problems. Can you take us through it step by step?
Right, okay. This chain of inferences is what many commentators found deeply problematic. It starts with the piece of evidence itself.
The complainant got into a male stranger's car and exchanged telephone numbers with him shortly before she met the defendant.
Okay, that's the factual evidence they wanted to admit. What was the first inference the court drew from that?
From step A, the inference drawn was that this behavior supports the inference that.
The complainant was not adverse to some form of sexual activity shortly before meeting the defendant.
Right, so from getting into a car and swapping numbers with one stranger, the jump is made to her general attitude towards sexual activity with a stranger around that time.
Okay, what's the next step in the chain?
From step B, her supposed non-adversity to sexual activity, the inference then leaped to, supports the inference
The
that.
complainant wanted to engage in sexual activity when she met the defendant.
Hold on. Now we've gone from a general not adverse state regarding a previous stranger to a specific desire wanted for sexual activity with this defendant, simply because she met him soon after the first interaction. That feels like quite a significant jump already.
It does feel like a leap, doesn't it? And the chain doesn't stop there. From step C, her supposed desire for sex with the defendant, it then infers dishonesty about her stated intentions. Supports the inference that. The complainant's statement that she accompanied the defendant just to see if they could be friends, and not for the purpose of engaging in any form of sexual activity, was therefore a lie.
Okay, so because she allegedly wanted sex, based on those earlier questionable inferences, her stated non-sexual reason for being with him must be a lie. And the next step seems to compound that presumed dishonesty.
Yes. From that presumed lie about her initial intentions, the inference was then drawn that it supports the inference that. Step D, again, really, the complainant's statement that she did not consent to the subsequent sexual intercourse was also a lie.
Wow. So we've gone from a presumed lie about why she met him to a presumed lie about whether she consented to sex with him later on.
Exactly. And the final step just completes that inferential chain, supports the inference that.
The intercourse between the complainant and the defendant must therefore have been with the complainant's consent.
Laying it out like that, step by logical step, really exposes the inferential jumps being made. What are the underlying assumptions or generalizations that seem to be propping up each of those steps?
Well, this is where the criticism becomes absolutely razor sharp. The inferences drawn in that chain seem to rely heavily on precisely the kind of broad, often discriminatory, and generally unsupported generalizations about female sexual behavior that the law is supposed to guard against.
Like what specifically?
Well, the leap from interacting with one person, getting in a car, swapping numbers, to being generally not adverse to sex, and then specifically wanting sex with a different person met shortly after. That seems based on assumptions about a woman's behavior being a reliable indicator of her general sexual availability or immediate sexual intent towards anyone she encounters soon after. And then the further leap from presumed dishonesty about her initial intentions to presumed dishonesty about consent seems to rely on stereotypes, suggesting that if a woman is deceptive about why she's initially with someone, she's probably also lying about not consenting to sex later on.
Which inferential step, or maybe steps, in that chain strike you as the biggest leap, the least logically justifiable?
That's a good question. Many legal commentators would argue that the transition from step B, general, not adverse state, to step C, wanting sex with this specific defendant, is a very significant and questionable leap. And arguably, the most problematic jump of all is from step D, presumed lie about intentions, to the other step D, presumed lie about consent, and then finally step E, inferring actual consent. This chain seems to link potentially unrelated behavior and presumed dishonesty in a way that feels highly prejudicial and appears to rely heavily on those harmful stereotypes about women's credibility and the nature of consent.
And this chain of reasoning sounds depressingly similar to, or at least implicitly supported by, those discredited rape myths we talked about earlier.
That is precisely why the Court of Appeals ruling in Mukadi, or at least this reported chain of reasoning within the judgment, has been subjected to such enormous criticism over the years. It appears on its face to rely on generalizations that closely mirror those twin myths, particularly the second myth, perhaps, that certain behavior indicates a woman is available or unchaste, and therefore less likely to be telling the truth when she says she didn't consent. It really highlights the persistent, ongoing challenge of ensuring that judicial assessments of relevance are genuinely based on sound logic and specific evidence, not on ingrained, discriminatory, and harmful stereotypes.
Okay, so pulling all these complex threads together now, the history, the statute, RVA, NOAA 2, the later cases, the Mukadi example, let's revisit some of those key critical evaluation questions that the source materials pose for us. Given everything we've discussed, particularly the case law since 802, should the fundamental question of whether sexual history evidence is relevant ultimately be left largely to the judge's discretion? Or was Parliament right back in 1999 to try and reduce that discretion to an absolute minimum with strict rules? What are the arguments on each side of that?
Okay, well, the arguments for favoring more judicial discretion tend to emphasize the need for flexibility. The idea that every case is unique and judges need the ability to tailor the rules to the specific facts they're dealing with. Proponents argue that judges, being experienced, are best placed to weigh the potential probative value of a piece of evidence against its likely prejudicial effect, right there in the context of that particular trial. They might point to RVA, Note 2 itself, as an example where, arguably, rigid statutory rules could have prevented a defendant from presenting evidence seen as crucial to their fair trial rights under Article 6.
Okay, that's the case for discretion. What about the arguments for minimizing discretion, the approach Parliament seemed to favor in 1999?
Well, those arguments stress the need for predictability, for consistency, and crucially for providing robust protection for complainants against questioning that's intrusive, irrelevant, and potentially based on prejudice. They contend that judicial discretion, no matter how well-intentioned, can inevitably be inconsistent. Worse, it might be susceptible to unconscious biases, potentially leading to irrelevant evidence being admitted based on those harmful stereotypes, as critics argue happened in Mukadi. They'd say Parliament's attempt to set a very high, clear, objective standard through that unsafe test in Section 41 was a necessary and deliberate response to the perceived failures of the looser, more discretionary 1976 Act regime. So how successful do you think Parliament's attempt to really constrain judicial discretion with the YJCA 1999 actually was in the end? Did it achieve that goal? Oh, that's the million-dollar question, isn't it? The picture is definitely mixed. Many legal commentators would argue quite strongly that the courts, particularly through the very significant interpretation in RVA, Note 2, using the Human Rights Act, have significantly diluted Parliament's original aim of severely curtailing judicial discretion.
How so?
Well, while the unsafe test certainly sets a high linguistic bar, the way the courts interpreted relevance, especially regarding history with the accused and the overriding principle that evidence might have to be admitted to ensure Article 6 compatibility, well, that has effectively reintroduced a significant degree of judicial discretion that Parliament seemed determined to remove. It looks like the courts were ultimately unwilling to apply the statute so strictly that it might demonstrably infringe fair trial rights. So we've ended up with a kind of compromise, where judicial interpretation plays a much larger role than Parliament probably intended back in 1999.
Which brings us to that really crucial and perhaps uncomfortable question the materials pose. To what extent, if any, do you think courts, and maybe even juries, continue to subscribe to or be influenced by those discredited twin myths we discussed earlier?
This is the really difficult, uncomfortable truth that the ongoing Law Commission review is trying to grapple with. Let's just quickly remind ourselves what those twin myths are, often referencing the Canadian case Seaboyer, which was actually discussed in RVA Note 2.
Is the idea that women who readily engage in sexual intercourse are somehow more likely to be raped and also less likely to report it if they are?
Is the idea that women deemed unchaste, an awful term, are more likely to consent to intercourse and also less likely to be telling the truth if they claim they didn't consent?
Awful myths. But do they still have influence?
Well, that's the concern. While judges now routinely give specific warnings to juries, telling them to guard against relying on these myths, the worry remains that the assessment of relevance itself, both by judges when they're deciding admissibility in the first place, and potentially about juries when they're evaluating the evidence they do hear, can still be subtly, perhaps unconsciously, influenced by underlying assumptions that align with these myths. The chain of reasoning reported in Mukadi, for example, is seen by many critics as precisely an instance where the court's assessment of relevance appeared to rely on assumptions mirroring that second myth that certain behavior implies dishonesty about consent.
And research into how juries actually make decisions?
Yes, research into jury decision-making, although it's methodologically very complex, also continues to explore the potential for these deep-seated societal stereotypes to influence how evidence is perceived and weighed, despite whatever judicial directions are given. It suggests it's a persistent, really difficult challenge to overcome completely.
So, even with the best intentions in the legislation and clear judicial warnings, the insidious influence of these harmful stereotypes might not be entirely eliminated from the courtroom process.
That is the significant ongoing concern, yes. And it's precisely why this whole area remains under such active review and debate. The law can set rules about what evidence is formally admissible, but ensuring that the evidence, once admitted, is assessed fairly and without prejudicial bias creeping in, that's a much harder task.
Looking forward, then, how could the law and practice in this incredibly challenging area potentially be improved? This is presumably what the Law Commission is wrestling with right now.
Exactly. The Law Commission consultation paper explores several possible avenues for reform. These include things like potentially tightening the statutory gateways in Section 41 even further, maybe with clear definitions of what constitutes relevance that actively try to counteract common myths. Or perhaps providing more detailed statutory criteria for judges to consider when they're exercising their discretion on admissibility.
What about procedures?
Yes, maybe improving the pretrial procedures for handling these applications to adduce sexual history evidence, making them more rigorous, perhaps less adversarial. Or, alternatively, maybe placing even greater emphasis on judicial directions and specific jury education about harmful stereotypes and assumptions, building on the existing guidance like the Crown Court Compendium we mentioned. The whole debate really centers on finding that elusive right balance between protecting the defendant's fair trial rights and ensuring robust protection for complainants from irrelevant prejudice.
So, by delving into all of this, the legislative history, the nitty-gritty of SS.4143 of the YJCEA 1999, the absolutely transformative effect of RVA 902, how it's been applied, sometimes controversially, in subsequent key cases like Martin, White, RVR, Hamadi, Beadall, and really dissecting that critical issue of relevance using the Mukati reasoning as an example and engaging in this critical evaluation of the ongoing debates. Hopefully, you listening should now be much better equipped to do a few key things.
Yes, hopefully you can now confidently describe the significant changes that sections 41 to 43 of the YJCEA 1999 brought in compared to the previous law under the 1976 Act. You should be able to explain the fundamental effect of RVA, no one need to, on how Section 41 is interpreted today and provide specific illustrations from the cases that have followed it. Importantly, you should be able to critically evaluate the law in this complex and often controversial area, identifying the key tensions and debates.
And crucially, especially for those of you facing exams, this detailed understanding is absolutely vital for applying the law effectively to practical scenarios, particularly those tricky problem questions you might encounter.
Absolutely. When you're faced with a problem question that requires you to analyze the admissibility of sexual history evidence, having a systematic approach is key. First step, clearly identify the specific sexual offense charged. In this context, it's usually going to be rape under Section 1 of the Sexual Offenses Act 2003, but check carefully.
Step 2. Figure out the specific defense or defenses the defendant is actually raising in the scenario. Are they claiming the complainant actually consented? Or are they claiming they had a reasonable belief in consent? Or maybe both. This tells you which issues are technically in the case. And always remember that crucial Section 42(1), for Section 41 purposes, a defense focused purely on belief in consent is not legally treated as an issue of actual consent itself. Keep that distinction sharp in your mind.
Okay, step 3. Pinpoint exactly what piece of evidence or what specific line of questioning the defense wants to introduce that relates to the complainant's sexual history or behavior. What is the specific information they're trying to get before the jury? More precise.
Step 4. Consider which of the potential statutory gateways under Section 41(3) the defense might be trying to argue the evidence fits through. Are they aiming for S.413A because they say it's relevant to an issue other than consent or belief, like motive, identity, source of injury, etc.? Or maybe S.413B because it relates to behavior very close in time to the alleged offense? Or is it S.413C because they claim it's relevant directly to consent or to belief in consent?
Right. Step 5. Once you've identified the potential gateway, you must then apply that strict two-part test for leave under Section 41. First, is the evidence actually relevant to that specific identified issue in the case? And second, if leave were refused and the defendant were convicted, would that refusal potentially render the conviction unsafe on appeal? Remember, both conditions must be satisfied.
And step 6 is where you really bring in all that case law we've discussed. Critically apply the principles established in RVA No. 2, and the key subsequent cases like Martin, Mukati, White, RVR, Hamadi, Beadall. Argue based on the specific facts presented in the problem, whether the evidence is likely to meet both the relevance and the unsafe thresholds, making sure you cite the reasoning from the key judgments to support your arguments.
Yes, and reference specific points from the judgments where they're relevant. For instance, you might need to discuss Lord Stan, the crucial distinction in A Note 2 about contextual relevance of previous history with the accused versus prohibited propensity reasoning. Or maybe you need to mention Lord Hof's examples for S.413a. Or perhaps you need to highlight the concerns raised by the Mukadi reasoning chain when you're assessing the legitimacy of the inferences the defense wants the jury to draw.
And finally, step 7. Conclude your analysis. State clearly what you think the likely outcome would be. Would the judge grant leave for this specific piece of evidence or line of questioning, or refuse it? And maybe offer a brief critical reflection on whether you think that outcome aligns with the objectives of the legislation and the ongoing need to balance fair trial rights with complainant protection under Articles 6 and 8.
And honestly, the sample examination questions provided in the source material are absolutely invaluable for practicing this detailed, systematic approach. Working through those scenarios, applying these steps, is really the best way to solidify your understanding and get exam ready.
Well, this has certainly been a deep dive into a profoundly complex but incredibly important area of evidence law. It really requires careful reading of the statute itself and very close attention to the nuances of how the judges have interpreted it, especially in light of the Human Rights Act.
It really does. And it just constantly underscores that enduring tension that sits right at the heart of sexual offense trials. How do you ensure a defendant can present a full and robust defense, including properly challenging the prosecution's case on consent, while simultaneously protecting a complainant from having their past sexual life unfairly scrutinized based on irrelevant assumptions and prejudicial stereotypes?
And perhaps the question that still lingers, even after all this legislation and case law, is whether the current legal framework, even as refined by cases like RVA No. 2, has truly succeeded in eradicating the subtle, insidious influence of those discredited rape myths from the courtroom process. It's clearly a challenge that Parliament, the courts, and indeed all legal professionals continue to grapple with. And that really brings us towards the end of this deep dive. We've navigated the legislative history from 1976 onwards. We've explored the core prohibitions and gateways in sections 41 to 43 of the YJCEA 1999. We've analyzed that pivotal and controversial RVA No. 2 decision and how it's been applied and debated in key subsequent cases. We've dissected the tricky issue of relevance using Mukadi as a stark illustration, and we've considered the ongoing critical debates and the possibilities for future reform.
And as we've said, mastering this area really requires you to go back to the source materials, read the statutes carefully, and engage closely with the detailed reasoning and the judgments of these key cases. Repetition and critical thinking are key.
Just a reminder that this deep dive was designed as an educational resource, building directly on the excellent materials made available by the University of London, and it was brought to you by Sinorbit Academy, Sri Lanka.
We sincerely wish you tremendous success in your continued studies of this challenging but vital area of law, and of course, the very best of luck with any upcoming examinations you might have.
Yes, very best of luck.